Good afternoon. This is Marcia Waters, Director of Doors Division of Real Estate. Today is February 5th, 2024, and the time is 2 p.m. I will now call the meeting to order. Before I call roll, I would like to advise the task force and members of the public that while the Division of Real Estate has been tasked with leading this task force and ultimately the issuance
sounds good. I can
of
do
the
that.
task force's report, the views, opinions, and recommendations discussed and expressed by the task force are not the views, opinions, or recommendations of the Division of Real Estate or the Department of Regulatory Agency. And with that, I will now call roll. Joe McConnell.
Present.
Dr. Davis. Natasha O'Flaherty.
Present.
Brian Matisse.
Present.
Bert Nadler.
Present.
Barry Wilson. I see his picture. Hopefully he can confirm his attendance here in a minute. Representative Parenti.
Here.
Senator Gonzalez. Marianne McGeady.
Present.
Christopher Elliott. Jennifer Tanaka.
Here.
And Steve Odorizio. We do have a quorum so far. Sarah, I'll turn it over to you.
Well, thank you, Marcia, and good afternoon, everyone. We are just going to go through a couple of quick slides here with a few just reminders for our meeting. So first and foremost, welcome. We are going to go through these items fairly quickly because one of our speakers does have a timing concern, so we're going to try to get through our administrative matters quickly. But the first thing I just wanted to remind everyone of at the top of these meetings is our meeting norms. It is really important that we just keep these in mind as we advance through our agenda today, and particularly when we get to the discussion, just keeping in mind these best practices and just taking responsibility for upholding them as a group. Wanted to just also touch upon our agenda. We do have a rather full one today. Our first topic is going to be on the HOA task force. As you know, this is a group that has been meeting since December, concurrently to the work of this task force. And under HB 1105, this task force is required to review and consider the policy recommendations that were provided by the HOA task force to Governor Polis in that December 8th letter that was provided to you in your pre-read materials. So we will spend about 15 minutes reviewing those considerations and talking about how they might have any impact on the work that we've been discussing as a Metro District Task Force. Our second topic that we will spend most of our time with today is on our tax levying authority and practices. We will start this topic with three speakers. We have Mayor Justin Brooks with the town of Erie, we have Peter Whitmore with Sherman and Howard, and we have Cynthia Thayer from the Colorado Department of Public Affairs. And after that, we'll be moving into our discussion. Now, just a quick reminder about all of our speakers. They are here just to provide educational content and really just help us have a good foundational understanding of current practices. And our guest speakers are subject matter experts, and they're here to support this discussion with the education, but they're not going to offer any personal opinions. So when we do get into that Q&A portion with our speakers, just a reminder to ask for those clarifying questions, but let's refrain from having a debate with our speakers and instead save that debate for our task force discussion. So the last administrative item that I'd like to cover before we begin is regarding our public comment period. As you know, this is something that the task force had requested earlier in our process, and so our next meeting on February 26th will be devoted entirely to public comment. As noted in our previous meetings, we know that you wanted to hear directly from the public, and so we have gotten some guidance from Dora on how this public comment period is going to be handled. First, members of the public who wish to speak at the meeting on the 26th will be able to sign up in advance using a link that will be provided by Dora. To help organize the discussion and align the contents or the comments with the topics that are mandated within HB 1105, members of the public will be able to sign up for a specific topic, but we will also have an option to just select a general comments topic. In order to ensure equitable input from as many members of the public as possible, testimony is going to be limited to just 3 minutes per participant. So if there are more people who sign up for sign up to speak, more than we have time to allow, Dora will administer a random lottery and notify participants that they've been selected. The form to testify will be provided by Dora and will be open from February 9th to February 19th. So for those of you who are tuning in, those of you who have been submitting perhaps written comment, just know that we have that option for your verbal comments at our February 26th meeting, and be on the lookout for that information from Dora when that sign-up sheet is ready to be used. So are there any questions from the task force on the public comment period or on our agenda today? All right, wonderful. Well, we will go ahead and transition to the first topic of our discussion today. Oh, yes, Natasha, I see your hand is raised.
Yeah, and quickly before we move on, and I don't know what the other task force members feel about this one. Is there any reason we would want to cut the public off? I would be fine extending that 2-hour period, depending. I mean, maybe we need the time, maybe we don't. But I think this is their chance to be heard, so I don't want to artificially limit it to 2 hours. I would defer to my fellow task force members.
Do we have other comments on that? Representative, yes.
I would concur with that, to allow a longer public commentary period if we get more signups than can be accommodated in the 2-hour period.
Other comments? Yes, Jennifer, I see your hand raised.
Yeah, I'm fine extending to within reason. I think we still need to have some kind of an outside limit so that we're not here for 8 hours or some kind of crazy amount. But I think having a reasonable amount of time to hear people within confines, I think would be appropriate. I think just for everybody's calendaring purposes, it'd be nice to have a defined period of time.
Great. Marianne?
Yeah, that was going to be my only comment, is to know whatever the outside time period is, to make sure that we all have it on our calendars so that we don't have something else booked after and not be able to hear all the comments. Because I think everyone is trying to be very diligent about attending the meetings, because we want to hear, be a part of all the conversation and hear all the comments. So whatever that outside time period is, we have enough time, it seems, in advance that we could accommodate it.
Great, thanks, Marianne. And what we can do is work with Dora's staff to see how many people are signing up and kind of assess at that point how many speakers that we would like to speak, and look at what the topics are that they're signing up for, and try to make some good decisions based on that feedback. So thank you all, appreciate that. All right, so we're going to go ahead and jump into a review of the HOA legislative considerations. So again, this was provided in your pre-read materials. It was a letter dated on December 8th to Governor Polis from the HOA task force. And if you didn't have a chance to review it, we do have the 6 considerations that were in that letter listed here. Now, just to be clear on what our mandate is as a task force, and I'm going to take this straight from the enabling legislation of House Bill 1105. Our job is to determine whether the findings and conclusions set forth in these recommendations apply to and provide guidance for this task force's own findings and conclusions regarding issues confronting Metropolitan District homeowners' rights. So, looking at these 6 recommendations, I do have a few questions to just start our conversation, but certainly we can kind of take the conversation as it comes. So the first question I have for all of you is, as you are looking to at these 6 considerations, are there any that rise to the top that could be specific items that might impact metro districts? And I see, Jennifer, your hand is up. Go right ahead.
Yeah, thanks, Sarah. I think what I was struggling with a little bit is these are pretty vague to begin with. And then also the vast majority of them, if not all of them, are really specific to HOA powers, not powers that districts have. There might be a little bit of overlap, but not understanding really what the concerns are. It's really hard in a vacuum to be able to say, oh, yes, we should address this here, because there's just no meat on the bones. I mean, we've certainly talked about, well, districts don't have special assessments. I don't know if they're talking about other types of fees. I think there's just some nomenclature things there that don't carry over naturally from HOAs to districts. So for me, I was almost feeling like once we get the final report, it'll be more helpful unless they're able to provide a little bit more context. For example, I don't think number 6 really applies to us. We have a public hearing process for districts, which is published and put onto the website, those types of things. I feel like that's probably something that's specific to the HOA environment itself as opposed to districts. Similar with licensure for association managers, as HOA managers are different from district managers. So I feel like a lot of these are either inapplicable or need a little bit more context for us to understand where that overlap could be.
Great. Thank you, Jennifer. And as a reminder to everyone, we do have a meeting scheduled in April for us to review and react to the HOA report. So to your point, Jennifer, I think we will have that opportunity in April. Brian, I see your hand raised. Please go ahead.
Thank you. I would agree with Jennifer Tanaka's comments in general. Many of these do seem to apply primarily to HOAs. I do think that there's a couple that apply to metro districts that have the ability to enforce covenants. In particular, I think topic number 1, explore the creation of an alternative dispute resolution process, would apply to metro districts that enforce covenants, because frequently there are disputes and an alternative dispute resolution on enforcing covenants would be useful. Similarly, perhaps number 5 would apply. Topic number 5 might apply to the extent that there is a manager for a metro district that is similar to an HOA manager that enforces covenants. But as Jennifer Tanaka stated earlier, in general, the licensure of community association managers is significantly different from licensure of metro district managers, and frequently the metro districts use attorneys and or accountants to do a lot of the functions that community association managers do.
Great. Thank you, Brian. I appreciate both of you being very clear on your comments. That really helps for our report writing. Other comments on any of these 6 recommendations? Are there any, I mean, I know we've talked about what things might apply. It sounds like there are a few things that right out of the gate, it seems like they may not apply just because of some of the reasons that you had stated. But anything else that stands out to you that really is unique to HOAs that would not necessarily translate to metro districts that we haven't already discussed? Yes, Representative Parenti, please.
Thank you. Yeah, just looking at the list, I agree with the comments of the previous speakers. In some of these cases, I feel like maybe a little bit more information about the issue would be helpful. I do think that there's potential overlap for sure in one for the same reasons that Mr. Matee spoke about. There might actually be some applicability for 3, which is that bill, I've just pulled it up, is very broadly drafted in terms of public rights of way. And so to that extent, metro districts do actually have quite a bit of influence over public rights of way and their role as infrastructure providers. So there may be, I would want more information about what they're looking for there. And also number 6, in the sense that we did spend quite a bit of time talking about voting governance, voting reform in our last meeting, and perhaps there's at least similar issues that people want to have addressed, even if we end up addressing them in very different areas of statute. So thank you.
Great, thank you, Representative. And I know we have some folks from the task force that hopped on a little bit late, so I just want to give you all some space and time to comment on these before we move on. Other thoughts on these in terms of how they might be related to metro districts or potentially have some additional application on metro districts? All right, wonderful. Well, again, we will be having another session in April with the full report from the HOA task force. So at that time, I think we will have some additional details around some of these considerations. So we will certainly know a little bit more at that point and be able to provide perhaps some better comment, or more detailed comment on some of these considerations. So again, just want to thank everyone for their time and attention on this, and glad that we had an opportunity to discuss this now so that we know what to look for when we have the report in April. So with that, we're going to go ahead and transition to our guest speakers today. So I'm going to go ahead and stop my screen share and just move on to this next topic. So this topic is on tax levying authority and practices. And I'm very pleased to introduce our first educational speaker. And I want to first also give a big thank you to Representative Parenti for helping identify our first speaker today, Justin Brooks, who is the mayor of the town of Erie. And Mayor Brooks, I know that you did not have much time to prepare for this meeting today, so we really appreciate your willingness to just jump into the discussion with both feet and share some of your experiences with the town of Erie. So, and I also know you have a hard stop at 2:35, so we want to make sure you have time to provide some of your comments for about 10 minutes, and then we'll have 5 minutes for Q&A before you have to leave. So with that, I'm going to just go ahead and turn the program over to you, Mayor Brooks.
Well, thank you, Ms. Reynolds. I very much appreciate being able to be here. So no matter how last minute it was, this is a topic that we spent a lot of time with in the town of Erie. As you might know, we're a very fast growing community, so we have a lot of development happening and a lot of new districts being created as a result of that. Also, thank you to Representative Parenti for inviting me to this as well. So I wanted to share a little bit of experience that we've had in the town of Erie regarding the creation and the management of metro districts. So many of the public, as they're moving to Colorado from out of state, or they're moving into newer subdivisions that were not previously established, they move into these metro districts, and they're not always familiar with what they are. And so I don't necessarily have to educate the task force on this, but for the public that's participating in this meeting, I wanted to make clear that the metro district's purpose is to be able to provide the infrastructure needs for the community as it is developed. And so there's an adage that's used during a lot of these public hearings that metro districts are the way for development to pay its own way. So in other words, if you want to provide water, sewer, roads, and those things to a new neighborhood, either the community would have to put those in place at the cost of the current taxpayers and future taxpayers, or you can create a special taxing district where the future residents of that community will then pay back the bond for that. And so when you create a metro district, and it can only be done by the municipality, it's a legislative action to create this body. And the act of creating a metro district is essentially creating a government body. So you're creating a taxing entity that has the ability to tax, to foreclose if it comes to non-payment of taxes. And so they have a lot of authority. And so in the town of Erie, we have several metro districts. Currently, we've had many over the decades past, and each subdivision often has multiple metro districts within it. So it's a little complex. It is an authorization for that newly formed entity to take on debt in the form of bonds and use that debt to be able to pay for that infrastructure. And then they're also able to have an operating margin as well. So in the town of Erie, until July of 22, we didn't have an official written policy for how you were to assess the applications for metro districts. And so our staff did a great job, but it was more of a negotiation and subjective as to how they would assess whether an entity was good for the community, or whether it was something that needed to be reworked and submitted to the Board of Trustees after it had been revised. And so in July of 22, we published, or approved, I should say, and then published a policy for reviewing service plans for special districts. And so this is sort of a guidebook or a guidepost for how we can encourage the metro districts as they're created to not only keep in mind the participation of the future homeowners and be subjectively fair to them, it's also a way for them to know what expectations we have in terms of our comprehensive plan and our build out of our city. So we want to make sure that we're encouraging the type of, as growth happens, we want to encourage responsible growth that allows us to have a sustainable community. So in this policy, which if for those members of the task force, I understand you have a reference library with documents. This has been added to it for you to look at in the future. It's not terribly long. It's about 14 pages, including the addendums or the appendices. But what it's meant to do, it's not a hard and fast requirement sheet. So it's important for you to know that it is sort of a guidance. So we want to encourage certain types of behavior and we want to discourage other types of behavior. And there's a point system that is applied to meeting certain criteria. Our staff works very closely with the applicants for metro districts prior to it coming to a hearing with our board, our council member now. We were a board of trustees before we've transitioned to home rule. And so when they come to us, it's often ironed out very well. We've had at least one, possibly two that I can recall. My memory is a little fuzzy on how many have come across my desk. But since this has been implemented, we've actually applied this to some newer metro districts. Initially, when we had a draft of this, we went out to the home builders in the area and the previous metro district applicants to kind of review with them what we were thinking and what types of criteria we were thinking of putting in this. Initially, it was met with a bit of resistance, and we were able to gather some feedback from the stakeholders as they were and incorporate a lot of that into the document. And I believe that we arrived at a good compromise that represents the interests of our taxpayers, because once we allow a special district to be created, it exists. It's not something that we can go and revoke after it's been created. It would be very messy to try to consolidate or take on the debt of a metro district in order to manage it differently than they are managing it. I'll also point out that each metro district is an independent body. Even if you have 5 metro districts inside of a single neighborhood, that's essentially 5 separate corporations that exist in that neighborhood, each with governmental authority as a taxing body. So I'll also say that once we had gathered that feedback and put it into a policy, one of the most vocal opponents of the policy's creation was the first applicant through the chute, if you will, for creation. And they complimented us after the process that it actually helped them hone in on what was important. They enthusiastically supported some of the objectives that we had, that we were trying to encourage in terms of the type of growth that we wanted. And it worked for them, and it worked for their stakeholders and their investors. And so they were able to create, they were able to gain authorization, I should say, to create their metro district. So we've had a very positive experience with having this guidepost as elected officials, as their terms turn over and you get new people. I know as a new council member, when I was first joining the board, I had my first hearing for a metro district within a month of taking office. I had no idea what I was really approving or denying. I didn't necessarily understand the legal ramifications of the decision that I was about to make. And so there are a lot of unanswered questions for the layman, not as well as the lawmaker, when you're trying to review these. And so I think having a written policy or a written guidance of what a metro district is, what type of interest should you be representing on behalf of the taxpayer that's going to have to pay for these, what type of limitations in terms of mill levy should you place on them, what type of tabor limit should be applied to the taxation. Those are things that need to be well understood and also communicated openly, both to the applicant and the taxpayer as you're going through this process. So I'm very thankful that we were able to go through this. I'm also very thankful that you guys are considering what type of more universal application can be applied to the management or creation of a special district. So thank you for what you're doing. I feel like I'm beginning to ramble, so I will end my testimony and I'll go to question and answer now if you'd like.
Yes, absolutely. And you're perfect on time, Mayor Brooks. And I know you just have a few minutes for some Q&A. So I'll open it up to members of the task force. And just a reminder that we're just seeking factual clarification, not engaging in debate at this portion. So Chris, I see your hand was up.
Yes, thank you. Wanted to thank the mayor. We are an active developer in the town of Erie with 2 new communities. We participated extensively through the process of creating the new guidebook, if you will, and think that it's working well. And we particularly like the disclosure requirements and the disclosure opportunities with the future property owners within the communities. And we think it's a good model for other communities to consider.
Thank you for that.
Thank you, Christopher. Bert Nadler, I saw your hand up. Would you like to go next? Did we lose Bert?
I don't see him on my Zoom.
I lowered
Okay.
I lowered my hand again. My
Okay.
question was answered. Thank you.
Okay, great. All right. Next up, I see we have Steve Odorizio, Commissioner. Go ahead.
Thank you. Can you guys hear me?
Yes, we can.
Yes, sir.
Okay. Thank you, Mayor. Mayor, thank you for coming and talking about it. It sounds like your goal is to try to find a win-win where it's not a question of getting rid of metro districts, but also trying to address some of the concerns that are out there. How would you, what I'd be interested in knowing, and I'm going to ask you this question, and the second question I don't expect you to answer is, how do you feel like the big changes that you guys were looking to make that found that that winning combination, that winning compromise, or that winning solution? And then the next question I'll ask is for the other members of the panel is to help explain later on how you guys see the difference between what the mayor's city is doing versus what is out there elsewhere. But that's not a question for the mayor. That's for the discussion later.
Sure.
Go ahead, Mayor.
I'll say that initially, the first draft that we had, it had some language in it that was it was an attempt to encourage behavior, but it spoke more to business practices. And our staff, we're not developers. We don't handle the lending side or investing side of the Metro District negotiation. And so that spawned some very good and sometimes spirited conversations between the people who were going to have these quasi regulations applied to them versus our staff who were really just trying to give some waypoints or some type of bounds for the elected officials and for staff to evaluate things from. So I think that we have been very clear with our developers on our market need for, as an example, affordable and attainable housing. We've also been clear with our development community about, the typical taxpayer, when they receive their property tax bill and they are mad about it, they're not mad at one line item in their tax bill. They're mad at the town they live in. And so we make it clear that, we're in this together. Once we approve this, it's going to go to taxpayers and they're not going to know the difference all the time between a metro district or the town. And so we want to make sure that there's good consumer protection or representation for the taxes that they're paying. And we want to make sure that it is a pleasant situation for both the Metro District, the developer, as well as the homeowner who is participating in that community and truly has ownership in the Metro District, whether they recognize it or not. And so I think that was a way that we got to a win-win, was recognizing that, you know, those different stakeholder points of view are distinct, and they have a common goal, which is getting the infrastructure in place and having it managed well. That's just good all around for everyone.
Great. Thank you, Mayor Brooks. All right, Brian, I see your hand is raised.
Thank you. Mayor Brooks, I have a quick question. When multiple metro districts are created in a neighborhood, as you indicated, that they sometimes create multiple districts and they're separate government entities, do you apply this policy to each of those districts separately or in the aggregate? And if you do it in the aggregate, how do you get around the possibility that the developer might start with the first metro district created that doesn't comply with the policy at all, and then never develop the remaining districts that would be the basis for complying with the policy? Does that make sense?
It does, and that's a very good question. And we actually are going to have that situation to some degree, as some neighborhoods have metro districts that exist, and then we have some that are yet to be created but are in the plan. And so when we review this when we apply this policy, it is for any new district service plans and any amendments to current service plans. And so we do consider each metro district separate, because that's the requirement for the quasi-judicial hearing that we're having. So we can't necessarily have the existing ones or any future development plans weigh into our decision for that one metro district. But we may have dialogue about how the district being reviewed will impact or be impacted by the surrounding development plans.
Thank you.
Right. And Mayor Brooks, I know you have just a couple of minutes before you need to leave. So
Yep.
I have Natasha and Representative Parenti who have their hands raised. So Natasha, do you have a brief question for the mayor?
I have two very brief questions. And I've only had a chance to briefly review your policy, and kudos to you and your fellow members on trying to address this. But it does say in section 2(i) and A number 2 that it's not possible to finance the public infrastructure proposed to be constructed without imposing the district without imposing these proposed taxes. Now, the SDA has come out and said that the cost of infrastructure is approximately $30,000. I guess to me, this assumption, and we've heard it in this committee, in this task force quite a bit, how did you arrive at that? Why could it not just be baked into the price? Is this an issue of finding better finance developers? Or when we're talking about $30,000 by using the SDA's own numbers, how did this policy rest on that the only way to build is with the imposition of these taxes?
This was actually a topic I recall from when we had the draft. We had a conversation with the builders about, I think it was the Home Builders Association and then some individual developers about this. And if you were to raise, and I'll mix a couple of things, right? So if you have a $400,000 house and it takes you $120,000 to get the infrastructure to the point of breaking ground, in theory, you could sell the house for $520,000, as you're saying, and just have that homeowner pay for the infrastructure as you go. But you would have to have a method of lending the money to the developer in order to get all that infrastructure in place. And so since you haven't sold all the houses yet, you don't have that money. And they would have to either take out commercial bonds, which are a little more expensive than the Metro District bonds, or the town would have to put out a bond on a ballot for development of a particular area. So there are other ways to do it. And I would say that we are suggesting in our document that it is the only way. There are other methods that are just, in our opinion at the time we wrote the document, it was just more costly and not as beneficial to the taxpayers. And also the market will demand what a house sells for, not necessarily what it costs you to build it.
Yeah, and that kind of brings me to my second question, then I'll defer to Representative Parenti. I understand from hearing from people that initially the review did ban the master servant structure to better protect homeowners, to give them a say. What was the thought of taking that out of the proposed policy?
We had some feedback from some metro districts that voluntarily saw that was a bad structure, in a sense that it concentrated all the fiscal resources into a single metro district. We wanted to give flexibility to metro districts in their creation, but we recognize in our experience that in the one instance that we had in town, it was not working well for the residents in that district. I'll also point out that every metro district, being independent, they're run like small businesses. Some are run differently, more involved, less involved with homeowners, and so you get varying results. And that was the thinking there. We wanted to get to a common denominator across all metro districts. So we did take out that restriction on master subservient metro districts.
Thank you.
Great. All right. I know Mayor Brooks is running a little behind schedule, so Representative Parenti, you get to have the last word.
Oh, thank you. I appreciate that. And thank you, Mayor Brooks, for coming today. I actually really keyed in on your comments about education for decision makers, for town councils and county commissioners who might be approving these metro districts. And just wanted to hear if the town of Erie had created any curriculum in that context, if you were able to get that education that you thought that your existing or future elected officials might need when looking at these, and if you have any recommendations for the task force.
So this policy document is that this is the here is what we as a town have adopted as best practice for the creation of a metro district. Again, if there's something that's slightly outside of these guidelines, it can still be approved at the subjective opinion of the board that reviews it. But we've spent a lot of time discussing metro districts. We've spent a lot of time talking to constituents about concerns, issues related to metro districts. We've also spent a lot of time working with metro districts to resolve some very important infrastructure problems that were happening in the town. So we've had a lot of hands-on experience, if you will, with metro districts since we wrote this. But this document is meant to be the starting point for that education. And when a new board is impaneled in our orientation, this is one of the things that we would review.
All right, wonderful. Mayor Brooks, I just want to thank you for joining us. Appreciate your time. I know you got to go, so thanks again, and we'll hopefully see you again another time.
Absolutely. Thank you very much. It's been my pleasure.
All right.
Take care. Bye.
All right. Thank you, everyone, for being flexible with the agenda today. I know Mayor Brooks really had to move quite a few things to make that happen, so we appreciate that. Our next speaker today is Peter Whitmore, and Peter is a public finance attorney at Sherman & Howard, a law firm that is based here in Denver. His practice focuses primarily on bondholder disclosure for local government debt, including special districts. He's also experienced with bonds issued by other local governments, such as school districts, cities, and counties. Peter previously served as bond counsel representative on the Colorado Municipal Bond Supervisory Advisory Board and has practiced public finance law in Colorado for over 25 years. So Peter, thank you for joining us today. We appreciate this. And I understand you have a slide deck that you're going to be sharing.
I do. Let's see. Is everyone able to see that?
Indeed, looking good. Thanks, Peter.
Excellent. Okay, well, thank you, Sarah, and thank you to the task force for having me. I appreciate the last discussion with Mayor Brooks, kind of the high-level policy decisions that a town or city makes. My job is to dive a little bit into the weeds of how special districts are authorized to levy taxes and what the limits are on those taxes. So let's dive right in. There are three basic sources for the authorization to tax and those limits. First are Colorado statutes, generally Title 32. The second is the Colorado Constitution, generally Article 10, Section 20, otherwise known as the Taxpayers' Bill of Rights, or TABOR. And the third is the service plan approved by the city, town, or county. A few general principles to keep in mind. I'll go through these quickly because I think we've already touched on those. Metro districts are generally formed to finance infrastructure necessary for new development. They can't be formed without the review and approval of a city, town, or county. The taxes they levy and the debt they issue, of course, have to comply with state law. Tax-exempt debt also has to comply with federal law in order for the interest on the debt to be tax-exempt. So let's turn to the first of the three sources of authority, and that's Colorado statutes. Metropolitan districts are special districts, of course, and as such, they are governed by Title 32. This part of Title 32 grants special districts a broad general taxing authority. The second bullet point there. Title 32 also grants districts the authority to issue bonds secured by those taxes with voter approval. And that voter authorization is valid for either 5 years or 20 years, depending on the circumstances. If special districts have debt service mill levies for multiple types of debt or series of bonds, they must certify those.
Peter,
yes.
are you showing us slides? Because we only see the first one.
Oh, I apologize. Is this better?
Yeah, that's great. Thank you.
Okay. Thank you, Commissioner Odoricio. Okay, here's the slide I'm supposed to be on. My apologies. I was pretty much through this slide. This is the statutory authority to tax. The final bullet point that I'll mention is districts may form sub-districts, which have their own ability to tax. Sub-districts are not used a tremendous amount in my experience, so I won't describe those too much, but just wanted to point that out. Okay, turning to the second source of authority, the Constitution, we're going to focus on TABOR. TABOR encompasses quite a few topics. The three primary ones that are at issue here, I think, are taxes, debt, and revenue. For taxes and debt, TABOR requires voter approval in advance. It's a little more complicated than that, as you can see from the quotes from TABOR there, but that's the general idea. For revenue, TABOR requires each government to calculate a revenue cap each year, which is generally the prior year's revenue plus an inflation index. And if the actual revenues of the government exceed that cap, the government has to refund the excess to residents or taxpayers. TABOR also, though, allows voters to allow the government to keep that excess revenue. And these are what are often referred to as debrucing or de-taboring elections. If a metro district or a city or another government has a debrucing election, it doesn't mean that it's exempt from TABOR. It just means that it's allowed to keep those excess revenues. And in a typical metro district election, all three of these will be voted. So a tax authorization, a debt authorization, and authorization to keep these excess revenues. And just to give you a snapshot outside of the district world, the Municipal League reports that about 90% of these elections have been approved in cities and towns, at least for the years indicated there. TABOR also contains a number of election requirements. I know you've had a separate session on elections, so in the interest of time, I'll skip those. TABOR elections in new metro districts, I wanted to talk about briefly. Typically, these elections are held early in the process, near when the district is formed, so that the necessary authorizations are in place so that the public improvements can be financed and built. Houses can't be built until public infrastructure has been installed. Title 32 accommodates this in the definition of eligible electors. And again, I don't want to spend too much time on that because you've had a separate session on elections. The ballot questions and table elections for metro districts can sometimes be a little confusing to people, I think. Colorado law requires that separate projects be voted in separate ballot questions. So a city, for example, is not supposed to vote 20 different projects in one ballot question. So when you translate this to metro districts, you'll often see a question for water projects, one for sewer, one for streets, one for parks, etc., which results in a lot of ballot questions. The dollar amounts of debt and taxes voted in those questions also tend to be high, to give flexibility in the future to allocate the debt between all those various purposes. So the voted amounts tend to be higher than what is actually planned to be issued. Regardless of that amount voted, however, metro districts must also operate within the limits of the service plan. And this brings us to the third source of taxing authority. As you know, the city, town, or county must approve a service plan. It must contain a financial plan. And as of about a month ago, service plans must also contain a maximum debt service mill levy and a maximum debt amount. So regardless of how much was voted, these limits, which are typically lower, are the ones that are going to apply because they're lower. So again, prior to this year, city councils and boards of county commissioners did not have to require those limitations. Now they do. As a practical matter, in recent years, most cities, towns, and counties have imposed those limitations. And as I said, in terms of a homeowner, for example, wanting to know what the maximum debt levy is authorized in any district in which they're going to live, and the maximum amount of debt, service plan is the best place to find that information. So I thought it would be helpful to run through a few cities as examples to see how this plays out in practice. I picked four.
Peter, we
Yes.
just have a couple more minutes left for presentation. Just wanted to give you that note on time.
Okay, thank you.
Okay, yeah.
So taking Aurora as an example, Aurora requires a service plan to have a maximum mill levy of 50 mills, a 40-year imposition term for that mill levy. So that basically means that no matter how much debt that district issues or what interest rate or what the terms are, the homeowners won't be taxed more than the cap and longer than the imposition term. Aurora does not impose a limit on the operations and maintenance mill levy. It does require a maximum debt limitation. Colorado Springs is very similar. You'll see, though, that some of the limitations apply only to residential districts. It does have a cap on the operations levy for residential districts. Erie and Denver take a somewhat different approach by requiring a maximum total mill levy, and then the districts have some flexibility to allocate that between debt and operations. But the end result is pretty similar. A maximum mill levy, a maximum imposition term, and a maximum debt limitation. The last thing I want to touch on is statutory legislative reforms, basically. This slide is a little dense, but just to make you aware, if you're not already, way back in the early 90s, there was some significant special district legislation that impacted debt and taxes. More recently, we've had the two transparency bills. As they pertain to debt and taxes, the 2021 bill requires disclosure of the maximum debt authorized by the service plan and the maximum mill levy authorized. And then in 2023, I've already touched on this bill, service plans must now establish a maximum debt levy and debt amount. And with that, probably out of time. Thank you for your attention.
All right. Well, we do have time for some Q&A. So there might be some content in Peter's presentation that he can fill in the gaps with based on your questions. So at this time, we can go ahead and take some questions from our task force members. I see Mary Ann right out of the gate. Go ahead.
Well, I just had a question. Peter, in your presentation, you mentioned how the maximum debt authorization might be voted in every question, but that would limit. I'm sorry, trying to spit it out, and I don't remember your exact words, but I remember you glossing over that topic of how you have a lot of questions that voted the maximum debt authorization in every question. So it might appear from the questions that you added up and there's a multiple, many times over total number of what the service plan limit is. Can you speak to how that relates to the service plan and why would they be voted that way?
Sure. The typical reason they're voted that way is if you had, say, a $10 million infrastructure project, and at the time the district was formed, the developer, the district, the city had a pretty good idea that the overall infrastructure would cost $10 million. It's not known exactly which component would cost which dollar amount. In other words, how much will the water be out of the 10 million? How much will sewer be? How much will streets be? So to provide some flexibility, those higher amounts are typically voted. But as I also said, or at least hope I did, the service plan limit ultimately guides the total amount of debt that can be issued by the district.
Thank you.
Great. Brian, I see your hand. Please go ahead.
Thank you. You'd mentioned on that same topic of voter authorization, you mentioned that voter authorizations tend to be higher than the amount required for the infrastructure. I have seen voted authorizations as high as $100 billion, billion with a B, for subdivisions that might have 10,000 homes in it. And it can total $3 to $5 million per home. Can you explain why there would ever be a need for voter authorizations that high, $3 to $5 million per home for maximum flexibility?
Yeah, I think it's basically the same answer. I don't think anyone intends for that amount of debt in total to ever be issued, but it provides flexibility to have debt allocated to the water improvements or the street improvements or the other different projects. As things change over time, plans may change, construction costs increase, et cetera. So I hope that addresses your question.
Well, I guess I'm still not sure. I mean, if we're talking about a number that is so outrageously high that it would never be achieved, like $100 billion, which would be millions of dollars per home, why couldn't they just authorize it later? If there's additional amounts needed, 10 or 20 years down the road, why wouldn't it be appropriate to issue more debt then instead of issuing this incredibly high amount at the beginning that you'll never use?
Well, let's be careful with terms. I think you just said issue debt. That amount of debt would not be issued. I think you meant debt authorized.
Authorized. Thank you for correcting me.
Yeah. And I think we have to be careful with that because the purpose of the Metro District is to finance the infrastructure for the entire development. So I don't think the developer and the city are interested in a project going halfway, let's say, and then the district's unable to finance any improvements after that. So the idea is to establish enough authorization at the outset for the district to be able to issue bonds and levy taxes for the entire project within the bounds of the service plan.
All right, great. Thank you. Jennifer, I saw your hand go up. Please go ahead.
Yes, thanks, Peter. Appreciate you putting this all together for us. We're talking about really the voter authorization, not issued but unissued, or authorized but unissued debt, and the limitations in the service plan as well as the limitations in the electoral authorization. But can you also talk about how this all dovetails with the market itself and how the market plays into a district's ability to issue the debt that's set forth in the service plan as well? And I know that's a really deep dive and so probably a high level, but if you don't mind just touching on that a little bit, that would be great.
Sure, happy to. I think that is a factor that's often missing from the debate and missing from my 10-minute presentation. So I apologize for that. But the ability of the bond market to absorb this debt of special districts is limited, and it varies in time. In years of the Great Recession, there was virtually no market for special district debt. So it doesn't matter if the district had authorized $1 million of debt or $1 billion of debt, it couldn't be issued. At other times, the institutions which buy this debt have a greater appetite for this kind of debt, and there's more of a market. But I have I've heard the unissued or authorized but unissued debt referred to as a credit card limit, and that's just not the case. A credit card limit implies that the credit card company has made a credit decision about all of that debt, and that's not the case with voted authorization.
Great, thank you. Natasha, I saw your hand. Please go ahead.
Peter, thank you for the information. I have 3 quick questions. It seems like we all agree in this task force that their education and transparency is key. Is there any reason, I mean, that the bond holders have a tremendous amount of detail that most buyers are not seeing? Would there be any reason why the detail that's offered to the bondholders is not shared with homeowners? So the same numbers in detail, not just what's the max levy debt, but the max debt issuance, I mean, what's already in existence. Is there any reason that couldn't be shared? Because it seems like we all agree that the more information, the better.
Yeah, in general, I would agree with that. And in the course of my practice, I've seen the availability of information grow exponentially. Part of that's due to legislation requiring more disclosure, but part of it's just due to technology also. County assessors have better websites. The state has a better website. There's just a lot more information available. One caveat I would put on that is when bonds are issued, a lot of consultants are hired to do projections and forecasts and financial modeling and so forth that cost money. Without bonds there to pay for some of that work, I'm not sure how it would get paid for just to have on a district's website. But in general, yes, I agree. All that information is public information.
Yes, actually that dovetails then let me jump to the next one. When you talk about the market, you're talking third parties, but the reality is, and I live in a district where tremendous amounts of, alleged developer advances move from an unsecured promissory note to a developer held. Would you see it be prudent to define for the homeowners what is being market debt to third parties versus to developer affiliates? I think that's where we've gotten into some rub with some districts.
I'm not sure.
I agree. Sometimes that debt is written off, but then the developer, like in our case, gets an $18 million tax write-off for a bad debt that's forgiven. But I agree with you that, yes, there were years where the market didn't have an appetite for muni debt from metro districts. But on the other hand, it does seem like a lot of this debt authorization is then issued to developers and their affiliates. Do you see a need to bifurcate that and make it clear to homeowners it's not just market conditions?
I guess I'm not sure of the question. I think if the question is, should homeowners know who holds the debt of their district? I don't know of any reason why they wouldn't know that or be able to find that out. Is that the question?
Maybe this question, I didn't phrase it well, is simpler. Of the disclosure, should it include the fact that this isn't just debt to the market, but it could also be held by developer and developer affiliates? Would that be a key disclosure?
I guess I don't have an opinion either way.
And I'm a homeowner to this panel, albeit serving on a district board. Can you just help me better understand I mean, on paper, it sounds great, and 90% approval doesn't surprise me. These debt authorizations are typically approved when the developer and their affiliates control the board, and as you said, at the inception. But when we look at Tabor in section 4B specifically, so once people like me buy a home in the district, explain to me why they don't get to vote when the bonds are subsequently issued, because typically once there's AV, then the bonds come. So in your mind, why is there no homeowner approval needed after that initial debt authorization levels when now the bonds are issuing? That's always been a rub that I don't quite understand.
Well, I'm not sure I understand exactly the timeline you're describing, but in general, the electors, the eligible electors as defined by Title 32 have voted, so the election has occurred. And then the district board is free to issue the debt whenever it makes sense to do so. And they do that at a public meeting where homeowners can come and give their thoughts to the board. And depending on the timing in the, when the homeowner moves in and when an election happens, homeowners can run for the board as well. So the answer kind of depends on exactly the timing you're talking about. But it's another way to look at it is if you buy a home in a district, you're also buying a home in a school district, in a city, in a county. And the school district is going to have a mill levy that's imposed, more than likely has debt outstanding. It may have authorized but unissued debt, and the homeowner is subject to all of those things too. And that's just part of the investigation of buying a home.
And Natasha, we're going to go ahead and move on to some other questions, but if you have questions after that, we can come back to you. Mary Ann, I see your hand is raised.
Thank you. And I wanted to ask Peter just about the election questions related to the general fund and operating expenses, because there's been some question about why those numbers are voted and why they're voted in such large amounts. And I think we all know that, once the community matures and there's other people on the board, they make their decisions about whether they want to use that authorization or not. But could you give some insight as to why those questions are voted the way they are?
What questions are you speaking of in particular?
I'm sorry, the operations questions, the general fund. We've been talking a lot about the debt taxation, but I just wanted to focus for a minute on the election questions. I mean, understanding how Tabor works and that districts begin with almost a zero assessed valuation. Why is it that they vote the Tabor questions they do for their general fund and operations?
Okay, I think I understand that. Yeah, the interplay of Tabor on all of this is pretty complicated. It was kind of designed for an existing city with an operating budget back in 1992, and it was adopted so that the revenue cap and all the restrictions of Tabor applied to the city as it existed at that time, whereas a metro district is a brand new entity that starts at a base basically zero. So it can't really operate without voter approval to, for example, retain its excess revenues. Is that what you were getting at?
Yeah, I think I just heard people say, why can't we revote, or start over with our operating property taxes? And in the communities that I'm familiar with, you're building infrastructure that has to be maintained, and there's no city or county or other entity that's willing to take it. So again, to my understanding, and that's why I'm asking if it's your understanding, if we don't vote that as a Tabor question when the community begins, you could get out a few years, have a bunch of things to maintain. And if you don't have the Tabor authorization to impose the taxes to maintain it, you would not, in the natural progression under Tabor, ever be able to catch up because your value started at zero.
Okay, I gotcha. Yeah, that sounds correct to me.
All right, Jennifer, see your hand raised.
Yeah, Peter, I just wanted to kind of going back to the debt question side of things. Can you talk to us about what protections are in place for taxpayers for debt issued by districts to ensure that there's not an over leveraging of debt that will then be overburdened on those taxpayers. I think there are a variety of different protections in place. If you don't mind reviewing some of those, that would be awesome.
Sure. I think the primary one is the service plan. As I mentioned, if we go back to some of these city examples, the service plans impose a maximum debt levy limit, maximum debt par amount limit, and a maximum debt levy imposition term. Is that what you were referring to, Jennifer?
Yeah, so I think there are those, and then I was going more toward the actual issuance, as far as market studies and different opinions and analyses that are done at the actual time of issuance. So that when we might have a debt limit of 100 million, but maybe we can only afford to issue a smaller amount, and what type of analyses goes into that?
Sure. Yeah. When debt is issued to third parties, it's usually to institutional investors who are capable of assessing the risks of a development in a district like this. They require feasibility studies be performed and stress tests and so forth to not guarantee that the debt will be repaid, because of course there's some risk that it won't, but at least to make an informed decision about whether it can be repaid and on what terms. So the district does have to go through a pretty strenuous underwriting process as part of issuing debt.
Great. Thank you, Peter. All right, we are running short on time, so I see 2 more hands raised, so we'll try to keep these questions brief. Commissioner Odorizio, I saw your hand first.
Yeah, can you hear me?
We can.
Okay, thank you. I'd like to go a little further into the question that Jennifer just asked, is a little bit more about these protections. And I understand the 2 things that were mentioned were the service plan itself, potential. That's where you could bake in either max mills, max durations, or other sorts of I guess guidelines or boundaries. And then you also mentioned the debt issuance process of underwriting. At the end of the day, one of the things that Adams County really looked at is that just because somebody sends us a report as a county, and I'm putting my county hat on, local government hat on, it doesn't necessarily mean that we had or were requiring people who understood these reports, people who understood what the analysis was. So what we've done in Adams County is require that these processes and these steps actually have a fiduciary to review and provide information and input. What I'm asking is, and I was told that that's not necessary and it's not required and it's not always consistent across the board, but I'd like to drill down, where does the buck stop? So if somebody's looking at that service plan and they do a really crappy job of it, how do we make sure that there is some accountability along the way? If somebody does a crappy job doing that issuance or that underwriting, where are the fiduciaries? Where does the buck stop? Where is responsibility begin and end for making sure that these steps and processes are done correctly? And maybe a brief description of what does fiduciary mean when people mention it, for those who might be watching who don't understand how important that designation can be.
Okay, thanks for the question. A lot to unpack there. The fiduciary is no, that's fine. A fiduciary is someone who owes a duty to another party. So in this context, it would be a municipal advisor or financial advisor who is looking out not for itself necessarily, but for another party like the special district. Cities in their service plans, cities, towns, and counties often require a fiduciary to be appointed, particularly where there is debt that is sold to the developer or someone related to the developer. And in fact, if you look at this slide, the bill passed last year, the 3rd bullet point near the bottom, that's talking about a municipal advisor and a fiduciary making reps to the district about the interest rate on the debt, et cetera. That only applies to debt that's sold to a developer or someone who has a conflict with the district. In a open public sale or public market. The market itself takes care of that, I think. These bonds are bought by institutional investors who do their own rigorous analysis of the debt and come to a appropriate interest rate in their opinion that the district's willing to pay and they're willing to accept. And that that essentially establishes the marketability of those bonds.
All right. Thank you, Peter. All right. Brian, you get our last question and then we'll turn Peter loose. So go right ahead.
Thank you. If you could put up the slide that talked about the mill levy cap for the city of Aurora, I wanted to clarify that a little bit. There you go.
Sure.
Now I just want to clarify. It says here the debt service mill levy is a 50 mil maximum, but in fact, for the city of Aurora, that is retroactively adjusted for all changes in state law that have occurred and had occurred since January 1 of 2004, more than 20 years ago. So in fact, the mill levy cap today, as of 2024, would be approximately 65.342 mils. Would you agree with that?
I don't know that I can agree or disagree with that number. I'm aware conceptually of what you're talking about. Yes.
You're not aware of, are you aware of the Aurora Service Plan's requirement to retroactively adjust it back to 2004?
Yes, as I just said, I'm conceptually aware of that. I don't know what the number is.
Okay, so then I guess the question is then, how can a homeowner who is not sophisticated, when they see something in a disclosure that talks about a 50 mil maximum subject to adjustment, how can that homeowner be expected to know that the maximum is actually a lot more than that, like over 65 mils today?
Well, I think Senate Bill 21262 is designed to address that with disclosure requirements to owners of newly constructed homes with the maximum debt and mill levy authorized. That's my understanding anyway.
All right, we do have one more speaker today. So Peter, thank you so much. This is clearly a very dense topic. We had a lot to unpack. Everyone had such great questions. And Peter, just genuinely appreciate you being a resource to this task force and providing all this information to help inform our discussion. So thank you so much for joining us.
Thank you for having me.
Wonderful. All right, so we do have one last speaker today. She's been terribly patient. Thank you, Cynthia, for letting us just ask additional questions of Peter. But I am really pleased to introduce Cynthia Thayer. Cynthia is the manager of the Local Government Services Unit in the Department of Local Affairs in the Division of Local Government. She's been with DOLA since 2003, and she's worked in various programs related to local government budgeting and finance. So Cynthia, thank you so much for joining us. We look forward to hearing a few minutes from you on the role of DOLA and some of the work that you do.
Thanks, Sarah. I have a message that I can't share my screen.
Oh, all right. Doris,
and if you'd like to pull, if you have my slide deck and would like to pull it up,
I do.
For me.
Definitely. Let me just pull that up really quick and I will share it. And then I can just advance the slides for you, Cynthia. Not a problem at all.
Thanks so much. All right, well, we'll go ahead and get started. Thanks, Sarah, and thanks so much to the task force for the opportunity. I'm, as Sarah mentioned, Cynthia Thayer with the Local Government Services section in the Division of Local Government. And the division administers multiple statutory programs with special districts, a few of which I'll mention today, that are broadly intended to improve public access to local government information and to promote and assure accountability of local governing boards. The division also maintains a public repository of various filings and information that local governments, including metropolitan districts, are required to provide. Next slide. Thanks. Most of the local government filings and information submitted to the division are from special districts, both in terms of the number of statutory requirements they have and the sheer number. As you probably know, special districts are prevalent in Colorado. About 60% or 3,000 of Colorado's As of Friday, more than 4,747, I believe, active local governments in Colorado or special districts, and almost 50% exactly in the state are metropolitan districts. The division also provides assistance and training to local officials and staff to help achieve statutorily directed transparency and compliance, and to generally assist them with effectively meeting the needs of Colorado residents. Next slide. And the division administers these programs and provides this assistance to local governments within Colorado's local control environment, where the state constitution and state statutes have generally been written to ensure governance is especially empowered at the level closest to those residents being served. And so consequently, the division cannot supervise, control, or investigate local governments. And the compliance roles it does have are narrow and specific in scope. For example, some related or adjacent to local government finance and taxation would be pursuant to the local government budget law, ensuring local governments, including metro districts, adopt and file an annual budget with the division, or Title 32, Article 1 special districts, which metro districts are one, are required to conduct board elections and file election results and director information with the division. The division also administers a statutory property tax revenue limit, which is different than Tabor, called the annual levy law. The nickname is the statutory 5.5 limit. And taxing entities, including metro districts, must either comply with the revenue limit or may ask voters to waive or exceed the limit. And then those taxing entities are required to provide the ballot language and election results, certify election results to the division. The division may also administratively dissolve 32-1 special districts if they have failed to adopt a budget, conduct board elections, or properly cancel elections, and have failed to prepare and complete audited financial statements for consecutive years. That statute does specify that districts with outstanding financial obligations or that provide services cannot be administratively dissolved. Next slide. In addition to the programs the division administers and the technical assistance it provides to local governments, staff also receives questions about local governments from the general public, including Metro District residents. And I don't have data, but taxation is one of, if not the most frequent topic residents often have. And I think it's also probably accurate to say we often get these questions around the time of property tax bills, so around this time of year. Because each district is different and has its own unique voter authorization, budget and revenue breakdown, Tabor status, service plan detail, it's difficult to provide a simple one-size-fits-all answer on why a resident's or homeowners' property taxes are what they are for their metro district. And the division also can't provide legal advice or give them legal interpretation about, for example, their district's Tabor status. But what we can do is explain how special districts work, generally operate, describe the requirements around taxation, and show them all the transparency information and sources available, and they have a right to, so that they can learn about the tax levy authority and practices specific to their district. So depending on the specific questions, this just gives some of the resources or information we might provide. We might generally explain the sources of authorization that Peter Whitmore talked about, or show them the specific filings within the online repository for their district. We'll potentially refer them to the Office of the State Auditor, who also has an online portal for audit filings from all local governments. We might refer them to the annual notice to electors, nicknamed the Transparency Notice, which has a summary of district contact information and meeting information, the most recent mill levy, and potentially explain open meetings and that the budget hearing is an opportunity for public input, and the 2023 legislation, I believe it was 23-110 that Peter Whitmore described, also has a new annual meeting requirement where public input is required. And finally, depending on the question, the service plan is often one of the first sources we'll reference and point a resident to, and we'll explain that the Board of County Commissioners or the municipal council or trustees approved it, and that in that service plan is a financial plan and financial assumptions. And we'll explain often that the service plan has historically often had and now is required to have mill levy and debt limits in it, which are a major piece of districts levying authorities and limits. Next slide. And finally, I'll end on the role of the approving county commissioners or municipal governing body in the service plan in terms of informing and limiting a metro district's tax levy and debt practices, and the importance it plays for the county or city or town and the constituents they will ultimately share with the district for years after the district is formed. I think Mayor Brooks said, "We're in this together." I think generally in my observation, in successful examples, counties and municipalities are very familiar with special districts and metropolitan districts and how they work as one local governance financing option. And they are intentional and deliberate about how metropolitan districts can fit into achieving their overall priorities, how they fit into their overall comprehensive plans and land use plans, housing plans, and as a way to provide infrastructure and services to the community. I think the approving governing board plays a key role in the review and specific content within the service plan, which Mayor Brooks touched on, including specific debt and tax limits, the financial assumptions, service levels and cost and standards within the infrastructure and services proposed. And I think it's also important for commissioners and councils and trustees to understand their authority to approve, disapprove, or conditionally approve a service plan, which the mayor touched on. And then after approval, the awareness of potential subsequent modifications or amendments to a service plan. And related to this and related to councils and commissioners overall planning in their communities, the division can and does provide technical assistance to those who ask and want it on board goal setting, planning. We, from time to time, will be asked to provide an overview of high level, what special districts are and what metropolitan districts are, how they work, or high level summary of the various financing mechanisms and local government types authorized in state statute, including special districts, but also potentially improvement districts and the distinct governing and finance and governance powers, governing board structures of each option, and which one might potentially help solve a problem or achieve the goals in a specific community. That concludes my information.
Wonderful. Thank you so much, Cynthia. For those of you who would have questions, now's your chance to ask Cynthia on anything that she's spoken about so far. Yes, Commissioner Odoricio, please go ahead.
Thank you. Ms. Thayer, thank you very much for taking the time to share that with us. I was intrigued a little bit more about some of the stuff at the end about the resources for governing boards. And I really appreciate that. I feel like some of the stuff that we had to do over the years has been kind of on our own at times. And now that you guys are coming in to help these other local governments, I think it's actually a really good thing. When you mentioned that you said there are model plans and there's different models out there, but is there like maybe a checklist or in your resources and technical assistance that you can provide to local governments, city councils, counties, others that would kind of help explain, hey, here's your role and here's why you have to do the service plan, and explain, because when I first got into this job and I started to understand, like, anytime somebody makes you approve something, there's usually a reason for it. And so you want to know what that is. You also know what the limitations of your responsibilities and your authority is in those situations. And so you have some of those technical assistance things that can help a new city council member, a new county commissioner really understand that. If not, is that something you guys could create? And then beyond that, go as you drill down into the job, understanding what are some of the options and conditions that we can and cannot add under the law that would make you say, hey, okay, as you go through, here's your roles and responsibilities as a city council member. As you go through, here's your role in the service plan. Here's your role in the annual review, meaning the city's role. Here's your role in the quinquennial review. Understanding and making it very easy for people to understand. And then also, hey, by the way, if you're concerned about this, here's a condition you can add.
Thanks for the question, Commissioner. I think generally the first place that a county or municipal board, often through the city or county manager, but not always, sometimes directly from elected officials, often the first place they will start with DOLA is the DOLA regional manager team. There's a team of 8 regional managers throughout the state. Most of them are former city or county managers or elected officials. Typically, it's pretty customized, but the regional manager will help talk through, hey, this is what we're looking at, and can you come talk to us? Or maybe even if we can't give the answer or no, we may have some suggestions on resources, other state agencies or subject matter experts that can help. So that's typically where folks start. And then the regional manager, depending on the specific subject matter expertise that specific board wants, may give us a call in the virtual Denver office, so to speak.
All right, wonderful. Representative Parenti, go ahead.
Thank you, Sarah, and thank you to Ms. Thayer for the presentation. I thought it was very informative. I had a question for you. I basically wanted to pick your brain on ideas for how to make it easier for homeowners, property owners to access some of that information that you were talking about. So we've got, for instance, in a metro district, you've got, the current levy, you've got the current authorized levy, you've got maybe the maximum, levy that can be put on. You've got maximum debt limits, you've got revenue limits, which are different than the levy limits, but not most people are going to understand that. And as far as I can tell, in LGIS, you all publish the current levy and the total assessed value, but a lot of the other information is not really there. What ideas do you have for how we can maybe communicate those more nuanced parts of how property taxes are calculated and so forth better to homeowners?
Thanks for the question, Representative. Off the top of my head, I hesitate. I don't know if I'm prepared to give a thoughtful answer. I think a couple thoughts is we could continue to think about this more and maybe through the department's legislative liaison, give you additional information or maybe get specific questions from you and give some recommendations on better public information or different public information. Also, coincidentally, we are currently working on modernizing what we call LGIS, or the Local Government Information System, both the internal interfaces and the e-filing portal that all local government officials are filing things through, as well as that public-facing source. So I appreciate the any suggestions you have. We are building that right now and have not yet built the mill levy piece. So the new modernized system will have some capabilities of spreadsheets and things. So historical mill levy and things like that are possible and things we're considering. So any additional feedback there would be great.
Terrific, thank you. Jennifer, I see your hand raised.
Yes, thank you. Thanks so much, Cynthia. This has been really helpful. And I have really two items, one that dovetails from what Representative Parenti was talking about, and then one following up on that. And that one note is that the DLG website does have a requirement where we have the district's website that then drives people to the district's website, which has the service plan, the budget, and that's all of what was part of the 110, Senate Bill 110 requirement for the items that have to be on the website. I think with the hopes of not having to overburden DOLA with having to have necessarily all of the documents specified in that on its website, but also then does drive homeowners from DOLA's website to the Metro District. So if that's helpful for people. But dovetailing onto the comment, I know we'd had this discussion for the last couple of years with DOLA that one resource that I personally think that would be helpful for people is a property tax calculator, something that they could go in and just plug in what's the value of their home or the assessed valuation that they receive from the county. If they're looking at a home, for example, maybe it's a $400,000 home, they're trying to determine whether they can afford the taxes and whatnot. They can input that purchase price. And then they could input the mill levies, whether it's district specific or whether it's overlapping for the full property. Then they could have an output that they could say, okay, now I have to pay in addition $2,000 on an annual basis in property taxes. I think a calculator of some sort might be helpful for people to really understand, because I think those of us that are in the industry know how to calculate and how to find some of this information. I can guarantee you that we're probably the 1%ers of the world of how to calculate property taxes. That's probably one of the biggest questions that I receive from homeowners is, one, how you calculate it? What does it even mean? What are the overlapping taxes? They don't know the basics of property taxation and how it works in Colorado. I know it differs from some other areas and from which they may be moving as well. I think maybe kind of a 101 or how to walk through your top property tax bill, how to calculate your taxes, how to find this information might be really helpful, a helpful resource. I know we've talked about it in the industry of different ways to tackle it as well, but I think if you tackle it in one area, it might be nice to be able to tackle it on a little bit higher level. So it's not just specific to one type of taxing entities, but so that they could actually find it for all different types of taxing entities, so that they're not under the belief too that I'm in a district, this is all my taxes, but they realize that there are school districts and cities and counties and library districts and conservation districts that also tax on that property as well, that add onto that RTD, et cetera. So that would be, I guess, one. And I don't think that you guys currently have a calculator, but if you do, then I apologize that I've missed it. But that would be something that maybe dovetailing from what Representative Parenti is talking about I think would be really helpful for residents and property tax owners.
I appreciate that. We do not have, the Division of Local Government does not have a calculator, but I appreciate the suggestion, and I'm actually going to reach out to our DOLA partners and the Division of Property Taxation to confirm that they don't either, and maybe put our heads together. Thanks.
Great.
Thank you.
I see, Joe, you have your hand raised, so please go ahead. Oh, you're on mute, Joe.
There we go.
Yeah.
Just to speak to one of Jennifer's concerns, I have drafted something to the effect of all local governments for homeowners. So that should be up pretty soon in the division.
Great, thanks, Joe. All right, Natasha, I'll let you take the last question and then we're gonna get into our discussion.
Great. And Cynthia, thank you for your time. And I agree that a calculator would be most helpful. I think there's very few people that know how to take their AV and determine each line item on their tax bill of what does 9 mills represent? I'd be curious to help facilitate this discussion as it relates to debt issuance. If you had to list the top 5 feedback you're getting from homeowners on this topic of what's coming into the division, what are the concerns you're hearing?
I don't know that I can come up with a top 5 and be confident. I don't have the data to know.
Or common ones. I mean,
Yeah, I
there's
think
some repetitive themes.
just overall understanding how these work, what they are. We heard about that, I think, earlier from Mayor Brooks. What is this district, and kind of understanding what metro districts do, what services, how they relate to an HOA or the county or municipality, which is so unique to each individual metro district. So that piece, and just understanding the process in general around local government budgeting, the mill levy, how it works, what it's going towards, how high can my taxes get? And that's, I think, where often that service plan maximum mill levy is a piece. Those are the main themes.
Thank you for sharing that.
Great. All right. Well, thank you so much for your patience, Cynthia. And really terrific job providing that overview from what DOLA is able to do and their role in this whole conversation. So we are ready to move on into our facilitated discussion. And I know we've had an opportunity to tease around a lot of these issues already just in our discussion with some of our speakers. So I do want to just start off with our first question, which is, as it relates to tax levying authority and practices, what is it that's working particularly well right now from a homeowner's perspective? Jennifer, go right ahead.
Yeah, this is where I think having the mayor on was really helpful, and also having Commissioner O'Dorisio on. I know that both Adams County and Erie have a model service plan and or policy for districts. I personally, as a practitioner, think that that's helpful. I think for my clients, it's helpful. I think for my residents, it's helpful as well. It sets out an even playing field. It sets out expectations. I think what is really important with it is seeing the differences in what each community has decided is best for its local jurisdiction. To me, I think that that's a really important thing to preserve, is that local control, because you do have things that Adams County might be focused on that are different from somebody in Swatch County or somebody over in Gunnison or different areas around the state. I think we have to be cognizant that we have rural areas and urban areas, and there are different needs and desires and wants and requirements for each of those different areas that are specific to those. And it's really up to those local elected officials to determine really what the important factors are there and what can be tolerated for that particular environment and what they're seeing, so they can address those. But I feel that that model service plan or the policies is a really instrumental component that has seemed to work well from my perspective and from my client perspectives as well.
Great, thanks, Jennifer. Other thoughts on what is working especially well relating to tax levying authority and practices? Or anything that has come up in our conversation today that you really want to highlight and make sure is noted? Yes, Representative Parenti.
Thank you, Sarah. I would just say that, I do think that the new rules, that are in place in terms of transparency and establishing maximum limits and so forth, I think those are good policies. I think we need to have a discussion, and we can wait till it's that part of the thing about how we enable or empower residents to remedy previous situations that they maybe aren't in a place to get out of now. And so I look forward to that part of the conversation later.
Great. That'll be our first one we come to, guarantee. All right, Commissioner Odericio, please go ahead.
I think DOLA is, I think DOLA is best. I think what I see now that is good is DOLA is best as a resource to help support local governments, empower them, and survive and serve as a resource to help local governments rather than continuing a trend to turn DOLA into an oversight regulatory body. I think that we need to be very careful about what we do with DOLA. And some of the trends that have been coming out of the Gold Dome have been trying to change it a little bit at a time. And what it's doing is it's hurting local governments. And so I just ask that whatever we do with the role of DOLA is that we keep it as a resource where you are excited to see them come to help you rather than nervous about seeing them knock on the door. And so we have a great DOLA, we have a great group, and we have people who are in those jobs because they want to serve as a resource. And I think we have to remember to keep that as a very positive interaction between local and state governments, because right now it's one of the few where it's really remaining really positive.
Great. Thank you, Commissioner. I just want to create a little space for anyone who has not had an opportunity to speak yet. Is there anything you want to add to the what is working well right now as it relates to taxation authority? Yes, Mary Ann, go ahead.
Yeah, I guess what I would say about what I think is working now, I would agree with the comments that Jennifer made about and Commissioner Odericio about having each county, city, town to develop its own policies, because in my experience working with jurisdictions across the state, each one is unique in terms of what is needed and what limitations make sense for what they're trying to finance and what land use objectives they're trying to achieve. And if a project is all residential, if a project is mixed use, if it's all retail, if it's a redevelopment, I mean, every configuration of land uses and infrastructure needs requires a different approach. And so I think the flexibility that there is now under the statutes and also how the election questions are voted. And I know this is not necessarily a supported position by everybody on the panel, but I just want to share that I think it's working well, that we have the flexibility to be able under the statutes and under the Constitution to vote in high limits so that the communities can attract the investment to build the infrastructure that's needed, because without the certainty that you can finish the project, you're not going to get the money in day one to build the project. I also think being able to vote in the high limits on operations and maintenance gives the opportunity for everything the community is committed to finance to be maintained in a way that the people who move in the beginning can continue and have their expectations realized that things are going to stay the same in terms of quality and accessibility to those amenities. And also the people who move in year 5, 10, 15, and 20, because completion of the development, if it's not assured in the beginning, will never happen. So I think for all those reasons, the flexibility that's currently there now is working well. I think the transparency changes that and best practice changes that have been added to the statutes the last couple of years are working well, but we need more time for them to roll out. I think some of the frustrations that people have is because they were moving into communities before those requirements were in place. And so they didn't get the benefit of those. And if we could go backwards in time, they would. But that's what I think is working well. Thank you.
All right, thank you. Thank you, Mary Ann. All right, so let's go ahead and transition now to the what is not working well, or perhaps just isn't working the way it was intended. And I know Representative Brenny, I promised we go right back to you. So why don't you expand a little bit more on your comment earlier on what's not working well?
Thank you, Sarah. Actually, I think it's exactly what Mary Ann was just talking about too. I mean, we do have a number of metro districts that were established before some of these more protective measures were put in place. And I think it's a legitimate question to ask of, how can we protect the homeowners who are in those situations, who don't have the voting power, right, to reestablish Tabor limits, or don't have the voting power to change their governance structure so that they can have that power. And, I think there's a significant public interest there, and would be interested in hearing ideas for how we can, make that better.
Mm-hmm. Great. Brian, go ahead.
Thank you. I think there's three categories of items that I think are not working well. First, the amount of the debt that is authorized in the service plan and the table of voter authorizations by the developer, the initial developer affiliates who vote, is often far in excess of the cost of the infrastructure that was intended to be financed. And remember, the purpose of metro districts is to finance this infrastructure. So there should be a relationship between the amount of debt authorized and some rational estimate of the cost of infrastructure. You know, often the authorization in the service plan is for billions and sometimes even $100 billion of debt to be authorized, which is far in excess of infrastructure costs, which may only be in the many millions of dollars. The market does not, the bond market does not provide accountability for that either. It doesn't offer the check that's provided because often developers can issue debt to themselves or their entities. What that effectively does is it means that for the next 40 years, they can essentially collect huge amounts of tax revenue from the property in the district and the property to be developed in the district, together with all of the increases in property values that may occur due to inflation or otherwise. The second concern I have is not working well is districts almost always have provisions in their service plans adjusting the mill levy cap for any changes in tax law that's adopted by the legislature. This does two things. First of all, it makes it very difficult, if not impossible, for homeowners to really understand what the mill levy cap is, because as I indicated before, Aurora has a provision in its service plans that it's adopted since 2004 that says the mill levy cap is 50 mills retroactively adjusted for any changes in the mill levy cap and in the legislative laws that occurred since 2004, which today means the mill levy cap is actually a lot higher, like 64.342. So it makes it impossible for homeowners to have an understanding of what their mill levy cap is. The other thing that it does, which I think is very dangerous, is that it means that any tax relief offered by the legislature, like the legislature did this past year during the special session, all of that tax relief gets gobbled up by an increase in the mill levy and the mill levy cap. So in the case of this past year's tax relief, homeowners in metro districts that had a lot of debt outstanding, they didn't get any tax relief at all. They had their assessed values increased by, they had their appraised values increased by 35%, and then maybe the 10 or 15% reduction that the legislature attempted to provide, all of that just went to a higher mill levy cap, diverting all that money to the bondholders of the developers. So there was no tax relief at all. The third thing that I'm concerned about that doesn't work well is what is effectively tax levying by Title 29 authorities. Now, we didn't talk about those today, but we talked about them in a previous session. Authorities are not supposed to have the ability to levy taxes. In CRS 29-1-203.5, subsection 2B, it says authorities may not levy taxes. But in fact, the intergovernmental agreements that are entered into when the authorities are created, and once again, these are single party agreements where essentially the developer signs for each of the constituent districts in the authority. It typically provides or often provides that the constituent districts must set whatever tax levy or effective tax levy the authority decides or requires. And therefore, what that really means is the homeowners really have no ability whatsoever to control their own mill levies. Thank you.
All right, thank you, Brian. That was a good list, a lot to unpack there. Natasha, why don't you go ahead? And I just want to remind everyone, we do want to have some time to be able to talk about solutions. So perhaps think about that right now as we're talking about things that may not be working well and be able to position that in terms of what a solution might be. So Natasha, go right ahead.
Yeah, I really have 5, and Brian already hit on 3s, but let me also preface mine. And, you know I speak for some other homeowners in my district, but I have to say, in these first 4 meetings or 3.5 we've had, I still think we're making some of these observations on what I would call incorrect assumptions or assumptions that are not based in fact. I think my biggest beef I have is that we cannot develop without metro districts. I live in a community, we have successful developments going on with no metro district financing. I think if you ask the average homeowner, would I rather take the SDA number of 30,000 per house in infrastructure? You know, if I run that on an amortization schedule and take a $500,000 home, as a homeowner, would I rather pay $530 and amortize that into my loan versus having a metro district where debt can stretch out to 40 years and I have the costs of supporting the metro district? So I really take exception that for this entire time that we have gone with this assumption that it is necessary for development. I don't accept that, and I'd be curious when we hear from homeowners, how many would rather have a metro district structure where generally half their tax bill is the metro district and the financing to support the governance of it, versus just adding that 30,000 SDA number into their loan. And, you know, I also hear that there's a time for homeowners to be on the board and there's a need to ensure that things get done. Again, I really take offense and exception to the idea that if you create a public entity, the time for the public participation in that entity is from day one, which brings me to my 5. I agree with Brian absolutely that one of the problems that has surfaced is the idea of the issuance of bond to the developer and their affiliates. These pledge agreements from a developer-controlled board to their entities, to me, that is just mirror on the wall. Should I do this deal after all? It is very self-serving. It generally does not serve the homeowners very well. And I agree, these problems have arisen from bad actors, but there seems to be no shortage of them. Then, to me, I would go one step further. One of the issues I see is that these Tabor elections prior to resident owning property in the district seems to be problematic. Then I'm still stuck on reading Title 32. I don't see where this master servant structure is provided. And it seems to be, again, where most of the abuses happen. I think as a homeowner, yes, I very much want my development to succeed. Yes, things have to be funded. Again, I go back to my simpler idea that I would prefer to have had that baked in the price of my home than through a metro district. So I would go with Brian's 3 suggestions of the issues and then add those other 2 of having Tabor elections prior to residents being in the district, and then this idea of a master servant structure that is not specifically addressed in 32 and does seem to be the root of so many of the issues that have been raised. So thank you.
Great. Thanks, Natasha. All right, we are going to just transition into some potential solutions. And Jennifer, I see your hand has been up, so let's go with you first.
Yeah, and this really dovetails onto a couple of times that Natasha has brought up a $30,000 amount. And I'm not sure where the SDA got that amount, Natasha, but I will say that it varies project to project, and it varies based upon the actual product they're producing. It varies on jurisdiction, et cetera. Because we've had analyses that have been upwards of 6 figures on a lot by lot basis. And in those instances, it's cost prohibitive for people to roll it into their mortgage because they can't afford a down payment. So I feel it might be helpful. I know we're limited on time and what we have left, but we've had some presentations from developers that talk about what goes into development and how it's not just a simple, well, you just tack on $30,000 to a lot price and then that, let them finance that mortgage. That's not as simple as that. Unfortunately, I wish it were, but I think having some of that background and understanding how the development works and how investors work with developers, how the pricing works, the timing of all of that, plus the component of a construction loan that gets rolled into that. So it's not just $30,000 that maybe the district might have to pay for, but there's also interest components that get rolled into that from a conventional construction loan component of it, et cetera. So it's a layered analysis that I think for me, it was really beneficial learning all of what goes beyond and behind all of that. And I think it might be, if we're going to be going into assumptions that people just shouldn't have districts just roll it in your mortgage, I don't think it's as black and white as that, as I guess what I'm kind of getting to on that. I think it might be helpful if that's where people want to go in that discussion, to have some of that background and have some presentations on that to provide that analysis. I also think that there is a balance here with affordability, with people even getting into the housing market. And it's not always an option for people to just roll something into a mortgage. Sometimes that just prices them out for coming up with down payments, et cetera. So getting onto solutions, I apologize. I've lost my complete train of thought because I wanted to make sure to address that because it was brought up several times. And I just wanted to make sure that we don't have something like that sticking out there that is sticking to everybody's head, that is just 100% the black and white number and also the rule. So I just wanted to say my piece on that. So sorry, Natasha, I just wanted to counter some of that information.
Well, Jennifer, if you think of that solution, I'll come back to you. So, all right. All right, Christopher, please go ahead.
Yeah, I would dovetail on what Jennifer said relative to the cost. Let's assume for a second that it actually is 30,000, which it is not. It is considerably higher. However, you gotta think of the whole purpose of all this, which is to finance. And 30,000 might be the hard cost. Let's say it is. Then you got to finance that at the initial construction phase, and you have that cost associated with it long before it gets to the home buyer. And then when the home buyer steps in and uses financing, you finance it again. So you've got financing costs at the construction time, you got financing costs when the home is sold as well. What I'd like to do is kind of bring us back to Erie, because it's near and dear to my own heart, because we have two communities there. And one of the things that we try and specialize in is what's really become infill master plans, where we come in and we acquire property through assemblage. And in the case of one of our Erie communities, some 25 different properties. Now, there's a reason that those 25 properties didn't develop, and that's because each one on their own was not able to afford to bring the infrastructure in necessary to make it work. One community provides the southern entry into the town of Erie and required a 6-lane boulevard road to be completed through it. On top of that, there's oil and gas facilities all over within that particular area of the metro area. And one of the things that we tried to do to address a whole separate issue, which is the oil and gas side of things, is to actually acquire all of the rights associated with all the oil and gas and plug and abandon every last well and move every last facility that was situated on our properties, so that the future homeowners weren't going to be in a position where they had oil and gas facilities outside of their kitchen window. We couldn't have done that in any way, shape, or form with the multiple individual properties that we had to acquire, and we couldn't have financed all those improvements, the roadways, the utilities, the oil and gas plugging and abandoning, all of the other infrastructure, if we didn't have the ability to go in and get the community up and running without the help of financing at a lower and more efficient rate. So it's essential in communities like that to be able to have access to a vehicle like a metro district to be able to fund those kinds of improvements. Now, one of the things that Erie did, and if you get a chance, take a look at what the mayor provided, but the rules, if you will, weren't just go and see what your capability and your capacity is for your districts to do it. Make sure that you do something within the community of Erie that's going to be necessary. And it's also going to be something that creates a benefit to not only your community that you're building, but the entire community of Erie. And so that was a high standard that we had to come back and show that we were meeting, that we were doing things, parks and trails and other recreation facilities, road improvements, water and sewer, some significant drainage improvements that had been passed by when prior areas developed. We came and were able to fix all those things because we had the ability to get a metro district, and that in turn was improvements that we had to demonstrate to the town were a benefit back to the overall community as a part of the approval process that they had. So take a look at that, and I think that that should help understand, particularly in areas where you're putting together larger communities that don't have the infrastructure available to it in order to make it work, but nonetheless is infrastructure that's needed for the broader area.
Great. Thank you, Christopher. So I see we are at time. So I do want to just do one last call. If anyone has a specific solution that they would like to offer right now, I can give you a couple minutes for that, and then we're going to wrap up. So we've got Commissioner Odoricio with your hand up. Go right ahead.
I have a question.
Mm.
Does there you heard that about Adams County, and you heard about Erie creating a model plan. Do other model plans already exist from DOLA that others are using or can use, and that might serve as kind of a baseline plan that is negotiated and agreed to by industry and community advocates, that kind of balances the interests or overlaps the interests of transparency, accountability, but also once you start creating a little bit more of a model plan, I'm not saying mandatory plan. Do you hear the difference, everyone? Model plan could serve as a starting point, but not mandatory. And the reason I say that is it still starts you out. It's kind of like the nudge. We're going to start with the default, but still have options to be able to move from there. I feel like that might be something that would be really good. Second, I'm going to come up to, sorry, Sarah, would also be, is there a standard set of training that we can find that this group agrees to that provides training and education for the consumer, for the decision maker, and for the board member who decides to serve on one of these special metro districts? There might be some overlapping modules in each of those, but there also might be some drill down points in such a curriculum that could really hit home of, as a consumer, here's what you should look at or what you can look at. Free market makes sense, but it requires that there be freedom of information, free flowing information, and freedom of choice by the consumer. Free market works when you have consumer power. And I think that the more that we can empower consumers to make good choices and informed choices, then it works. If consumers right now feel like they don't have a choice or they don't have information, then the free market doesn't work. We need to fix it. Thank you.
Thank you, Commissioner. All right, Marianne, quick solution. You're on mute, Marianne.
There it goes. The Special District Association does have a lot of information and is available for education. And so I think one solution might be for DOLA and SDA to kind of get together and see what they have, and then maybe reach out to see, as Commissioner Odoricio was suggesting, and the mayor, to kind of aggregate the policies that different communities have in like a resource database. I think that's a great solution. I don't know that legislation is necessary for all of that, but I think maybe communicating and making available what already exists, and as it improves over time or evolves over time, could be a good resource. I guess I just want to say, I'll be real brief, but on Brian's 3 points, I mean, on the first one, I want to say, I do disagree that we need to do anything about the debt authorization numbers because debt authorization is not debt issued, and the limits that are in the service plans constrain that. I think we've heard that several times. I do think there's a danger in trying to legislate downsizing of debt authorization because it is not the case that you know the construction costs at the time a service plan is done for most projects, particularly because many projects take years and years and years to facilitate. And if we compare construction costs from 2005 to 2000 now, and some of these projects take many phases, you would see such a great increase. There was no way to predict it. I also want to clarify something. I wasn't suggesting that there are bad districts out there that need to be fixed. I was just saying that in terms of the transparency and information being available that people might have purchased before that information was as accessible as it is right now. What I would say on those adjustments to the mill levy caps, such as the adjustment in Aurora, Aurora now has a disclosure requirement that has you calculate on the actual number. So you do have that mill levy number that helps to calculate at the time of your purchase. And again, I think with more information being available to people on how they could calculate, as Jennifer had suggested, maybe to have a centralized calculator that could help bridge that understanding gap. So thank you.
Excellent. All right. I see two more hands, so we're going to take this very quickly and then we're going to wrap up. So Brian, you'll go first, and then Joe, I'm going to let us end with you. Go ahead, Brian.
Thank you, Sarah. Very quickly, I think the solution should be number one, the amount of the debt authorized in a service plan. There should be a requirement that the amount of debt authorized in a service plan and the voter authorizations must have some rational relationship to the cost of the infrastructure. I'm not saying dollar for dollar. I could see maybe 100% increase available based on projections, just in case there's a lot more inflation that's expected, but it certainly shouldn't be completely irrational, completely unlimited. Second, I think that with respect to these adjustments, the legislature should provide that these adjustments would be appropriate. The adjustments in the mill levy cap would be appropriate if, for example, it would result in a decrease in the amount of the property taxes that would be collected from a prior year. But in like this last year, where the value of the property, appraised values went up 35, 40, 45% in some counties, there should be an ability, or there should be some restriction on the ability of the service plan to prohibit the legislature from providing tax relief. And then third, I think there needs to be explicit provision that Title 29 authorities can't circumvent the prohibition on them levying taxes through intergovernmental contracts with their constituent metro districts. Thank you.
All right, thank you, Brian. Joe, I'll let you have the last word. Solutions.
Well, just really quickly, Commissioner Odoricio asked about available resources at DOLA. We do have a couple of service plan documents out there. One of them is kind of old, but I don't think it's the type that we're really talking about here. It's more geared towards, residents who want to create their own district rather than, a model service plan. There is a template, I guess you could say, but it wouldn't be anything prescriptive. It's just, if someone was to contact us, we'd say, well, we know Erie has one. Maybe take a look at theirs, or Brighton, something like that.
Great. Thank you, Joe. And I just want to note, just in case the chat is invisible to some of the viewers, we did have a recommendation from Commissioner Odoricio that some legislation could be created to provide funding for some of the implementation of the ideas that we've heard today. So that is a solution I just wanted on the record, noted for the record, in case you could not see the chat. So thank you, Commissioner, for that suggestion. Appreciate that. So with that, I just want to review the last couple of phases of our work here today. First and foremost, just a reminder that we are going to have that public comment session on the 26th. That is due to the President's Day holiday on the 19th. So we have moved that meeting to the 26th. Dora is going to be providing that link for folks who want to testify or provide comment for them to be able to sign up. That is going to be on February 9th, and then that'll close on the 20th, or sorry, on the 19th. And what we will do at that time is we'll assess how many speakers we have signed up for each topic, and then make a decision with Dora on the total time that we will have for public comment, try to get as much public comment in as possible, understanding that there may be some time limits to task force members' time to be able to stay indefinitely on a call. I also wanted to just point out, in case it wasn't clarified earlier on, that in addition to the public comment, we are building in some time for task force discussion and reflection after that comment. So to get to some of the comments that we've heard from you throughout this process, is that you do want a chance to reflect on what people are saying about their experiences in metro districts, and we want to give you that opportunity to process that as a group and discuss it, so that those notes can also be included into our final report. So our time will be inclusive of not just comment, but also that reflection time. So just want to make sure that was clear for everyone. And then our very last meeting is going to be on April 22nd. That is for that final review of the HOA task force report, where we'll be reflecting and providing comments on that as well. I'll turn this back over to our task force chair, Marcia. Is there anything else you'd like to point out before we adjourn?
I don't have anything additional. Thank you.
Wonderful. Wonderful. All right. Well, thank you everyone for your time this afternoon. This is a very good conversation, a very complex issue. You've done a wonderful job unpacking it as a group, though, and coming up with some great discussion. So thank you all, and we look forward to seeing you at our next meeting on February 22nd or 26th. Yes.
Link for the public, if we want to share that in our respective metropolitan district communities. How's that going to be shared with this panel and with the public?
Good question. Yes, Dora team, do you want to answer that?
So once we get it set up, we can definitely send the link out to all of you.
And then task force members can share that with their networks if they wish.
Yeah. But we'll also do an announcement of some sort so that the broader community is aware that it's set up.
That'd be great. Thank you so much.
Wonderful. Thank you. All right, everyone, have a wonderful evening, and we'll see you in a couple of weeks for our next meeting. Take care.
Bye-bye.